Dear colleagues, distinguished guests, ladies and gentlemen, it's my pleasure to moderate this panel on collective countermeasures. My name is Tomáš Minárik, and I'm the Deputy Director of the Department of International Cooperation and the European Union at the National Cyber and Information Security Agency of Czechia, where I had the privilege to participate in the drafting of the Czech national position on the applicability of international law to cyberspace. I formerly also worked at the law branch of the NATO CCD-COE, and I'm still part of the Cyber Law Toolkit team as a managing editor. So the topic of collective countermeasures is frequently being discussed in the cyber context, both in academia and by the government, as shown also by the growing number of national positions taking a stance on the topic. And the goal of this panel is to perhaps explore some of the practical implications of accepting the applicability of the concept and maybe a way forward from the operational viewpoint, but also from the perspective of state responsibility as such, and also the perspective of international cooperation, both bilateral and multilateral. And we have three distinguished panelists here. So first, Gwendolyn Strasberg, who wrote an excellent thought-provoking article that you may find in the proceedings on establishing an unwilling or unable analog for deploying collective countermeasures in cyberspace. Gwendolyn holds a JD from New York University School of Law and works in matters of cyberspace and national security. She also completed a Master of Public Diplomacy from USC Annenberg School for Communication and Journalism and bachelor's degrees in Political Science and Spanish from the USC Dornsife School of Arts and Sciences. She's also an officer in the United States Marine Corps. Welcome. Second, we have Lauri Krisa, who has worked for the past decade as a legal and policy expert in national security. And he leads the legal department at the Estonian Information System Authority, RIA, tasked with ensuring the cybersecurity of the country. Previously, he served in various roles at the Estonian Ministry of Defense, including head of international law, deputy director of the NATO and European Union department, and director of the legal department. His expertise includes legal and policy issues regarding cyber operations, and he also collaborated on developing the Estonian 2019 national position on international law in cyberspace. He has graduated Tartu University with a bachelor's degree in law and Leiden University with an LLM in international law. And he has also concluded conscript service in the Estonian Defense Forces. He's a reserve officer and a member of the Estonian Defense League. Welcome. And last but not least, Stephen Hill is the Executive Secretary of the International Institute for Justice and the Rule of Law, IIJ, where he leads work with criminal justice practitioners around the world as they handle cases at the intersection of law, security, and technology. And he previously served as Chief Legal Counsel to NATO Secretary General Stoltenberg in Brussels and as Director for Global Criminal Justice on the National Security Council at the White House in Washington. And his work has consistently explored the legal dimensions of emerging technologies. He served as an expert contributor to the Tallinn Manual 2.0 and has regularly lectured in law courses at the CCD-COE and published several articles on NATO's approach to international law in the cyber context. And he's a vice president of the American Society of International Law. So welcome. We'll start with the presentations and opening statements of the panelists, followed by questions from the audience and perhaps from me or from each other. So with that, I'll pass the floor to Gwendolyn. Thank you.
Good afternoon, ladies and gentlemen. My name is Gwendolyn, and I'm here to talk to you about how we can take collective countermeasures from an academic theory to an operationalized tool. Now, I'm here from the Marine Forces at US Cyber Command, but I'm speaking in my personal capacity, and the views that I represent are not necessarily those of the DoD or the United States government. So why are we talking about collective countermeasures? As many of you likely know, in 2019, the president of Estonia stood at this very conference and endorsed collective countermeasures. The president announced that states which are not directly injured may apply countermeasures to support the state directly affected by malicious cyber operations. This adopted a collectivist approach to countermeasures. So why is this development necessary? Well, there's three key points here. Cyberspace is interconnected. Our networks overlap and weave together. and this subverts traditional norms of territorial sovereignty. This matters because it means that malicious cyber actors in one state can affect other states very easily. We also don't all have equal capacity to handle threats in cyberspace. And although we're unequal in that way, we're still all neighbors, as we've discussed. So this means that many countries have vulnerable networks and are interwoven with ours. That means even if my cyber defenses are extremely strong, my neighbors could be weak, and that causes a problem. And finally, we as lawyers need to catch up. The law necessarily lags behind the development of technology, but as we are trying to regulate a field where technology is rapidly proliferating, we notice that conflict online looks very different than conflict on land. This means that transposing those laws is a very difficult task. That's where things like the Talon Manual do come in. And it's why countries like Estonia know that we have to be innovative in our approach to law in this field. So let's set our legal foundation so that we're all on the same page. We know that Article 51 gives countries the right to self-defense if they face an armed attack. In the early and mid-2000s, collective self-defense emerged in the context of kinetic warfare. We interpreted Article 51 to say that a third party can respond to an armed attack if a territorial state is unwilling or unable to neutralize the threat itself. Today, a majority of us recognize a collective mechanism for help in the self-defense realm above the use of force threshold. Below the use of force threshold, we have countermeasures. Article 49 allows states who suffer a violation of an international obligation to take otherwise unlawful actions against the responsible state. But as far as a collective mechanism below the use of force threshold, we don't have one until collective countermeasures come in. Now, having a gap here poses a risk for us because there being a gap does not mean that people will not try to act in this space. They just might not act in a way that we would like them to. And if you leave the gap, you create an incentive to overclassify. You give people a reason to find themselves in the realm of self-defense where you have a collective mechanism. You give people a reason to escalate conflicts rather than provide a more peaceful remedy below the use of force threshold. But this is the law. We can't do anything without authorities. And that's where countries who don't sign off on collective countermeasures have questions. They want to know what is the legal justification for this concept. Well, in the early 2010s, when collective self-defense was the issue, a professor named Ashley Deeks from the University of Virginia mapped out a legal framework and traced collective self-defense to the due diligence obligation. And this is where my research picked up. I wanted to know, can we trace collective countermeasures back to the same place? Do collective self-defense and collective countermeasures share more than just the word collective? Well, I think that they do. You see, we all agree that there's a due diligence obligation in cyberspace, but that's reflected across every country's position paper. You see, the due diligence obligation can be traced back to a much older principle, the law of neutrality. This is a complement to the prohibition on aggression, and one requirement of the law of neutrality is that neutral states attempt to stop violations of neutrality by belligerent states. It's from the law of neutrality that we incur a due diligence obligation. This requires states to prevent violations of neutrality, and this is accepted in cyberspace. So we would say that from this due diligence obligation, we have territorial states which are unwilling or unable to repel the bad actor in accordance with due diligence, assisted by Article 48, Section 1, which will allow a third party to take collective countermeasures to assist the injured state and induce compliance with international obligations. This is all to say that a state is prohibited erga omnes from acts of aggression. They incur an obligation of conduct to exercise due diligence in addressing threats emitting from their territory. A state is prohibited erga omnes from acts of aggression, and the due diligence principle is widely accepted. These are established principles of law. But legal justifications only help us as far as we can use them. We need a unified standard by which we can apply collective countermeasures in cyberspace. We need a test to apply them. And this was the second part of my research, where this group's expertise can be invaluable. How do we balance factors and account for injured parties in service of a collective interest? What I came up with was a 4-part balancing test, starting with the consent and cooperation of the injured state, the necessity of a third-party intervention, the desired end state of the collective countermeasures, and compliance with the international law on countermeasures. Where a state is unable to respond itself when a state is unable to respond itself and a third party steps in with the consent of that injured party, there's a strong case for collective countermeasures. But by that same logic, we should also give the denial of consent by an injured state extreme weight. But you see, unlike in collective self-defense, we cannot allow consent to negate the rest of this analysis, because we have to contend with the ICJ's opinion in Nicaragua. There are 4 different avenues by which academics think that we differentiate collective countermeasures from the prohibition in Nicaragua. The first is that countermeasures occur below the use of force threshold. The second is that we're dealing with an erga omnes violation linked to the law of neutrality, the prohibition on aggression, and the due diligence obligation. The third is that cyberspace is inherently different from the kinetic realm. Nicaragua is a 1986 opinion. It could never have contemplated the complex nature of sovereignty in cyberspace and the risk of asymmetry that we're facing today. And finally, we have consent of the injured state. This is our best tool to keep collective countermeasures outside of the prohibition from Nicaragua. Moving on to necessity, the greater the threat is to the international community, the more necessary third-party action becomes. So broadly, this is going to encompass things like projected political and diplomatic ramifications, disruptions to businesses and trade, international norms and cooperative challenges. More specifically, this will consider the technical risks and the nature of the individual threat. Now, technical risks are necessarily going to be a fact-dependent analysis, but we would consider things like the pattern and severity and frequency of the activity and the control and capabilities of the parties involved. Essentially, what we're looking for is the wisdom of this intervention. And so it will boil down to how savvy is our victim and how dangerous is the threat. The bigger the difference there, the stronger case you have for collective help. Next, we have to consider the end state. Countermeasures must induce compliance with international obligations. That means we need the right target for the countermeasures. So first, we need to look at who is responsible. Is this conduct attributable to a state or not? If it's attributable to a state, and the state is unable to address that threat itself, then collective countermeasures would be used directly against the responsible state, asking them to come back into compliance with international obligations. Now, if it's a non-attributable threat, then we need to look at whether it's an unwilling or an unable territorial state. If a territorial state is unwilling, then the collective countermeasures would be enacted against the territorial state in order to ask them to come back into compliance with the due diligence principle and police their own territory. If we're dealing with a territorial state that is unable, then we use the collective countermeasures directly against the non-state actor themselves because they are the responsible party. Now, this is probably the most controversial application of this doctrine, but it is contemplated by the 2nd edition of the Talon Manual. The question remains if it's a palatable application. Finally, any countermeasures still need to comply with international law. This means that they need to respond to a prior breach of international law, they have to target the responsible party, they need to comply with the proportionality principle, they must not involve a use of force, and they must be reversible once the responsible party resumes compliance with its obligations. Now, this test is a starting point for a principled and consistently replicable framework for the collective safeguarding of cyberspace. Some are hesitant to develop the law in this direction, but regardless of our action, the gap does exist. Collective countermeasures are a crucial tool below the use of force thresholds for policing malicious cyber activity and maintaining a peaceful network. The hope remains that with development, a unified standard for collective action will allow state practice and opinion jurists to mature, lending further support for the collectivist approach for countermeasures and giving the international community the tools that it needs to maintain a secure and peaceful global network.
Thank you, Gwendolyn. I might have a follow-on question onto your presentation, and that would be regarding the unwilling or unable test, which is originally from collective self-defense, how that would be converted to collective countermeasures. So given the different legal foundations, use of Bellum versus state responsibility, do you think this blending could conflate or distort the distinct thresholds that these doctrines are meant to uphold?
Yeah, so I think that those distinct bodies of law apply really well to the kinetic realm, and they really struggle in the cyber realm, right? When we're talking about a threshold for an armed attack, we are consistently seeing action below that threshold. So if we are unable to at least learn lessons from one field, we're going to really struggle in regulating a body of law that is almost all occurring underneath the armed attack threshold. I also think that you don't have to blur that line in order to learn from each other. These tools are distinct in themselves, right? The tools are going to adhere to their respective fields. When you're using collective countermeasures, you are necessarily underneath the use of force threshold. You are necessarily responding to a prior breach. So I think that there are kind of some safeguards inherent in the doctrine that will keep them cabined away from each other. But I also think it's really important that we recognize the need to learn from these fields and to recognize the natural relationship between state responsibility and ad bellum.
Thank you. So, following this innovative input by Gwendolyn, next Lauri will provide the perspective of, well, I shouldn't probably say Estonia, maybe there will be some disclaimers, but Estonia first embraced collective countermeasures in its national position already back in 2019, as we have heard, and this morning, we also heard that Estonia might follow this up with a third iteration of its national position. So we may expect further elaboration in this regard, I suppose. So, looking forward to your presentation.
Good afternoon. To start with, this is not the third iteration of the Estonian official position. This would come in the official form. The views I'm going to present are those of my own and do not reflect or are not intended to reflect any official position of Estonia or any other entity. What they are inspired and in line with the 2019 position. When President Kersti Kaljulaid first presented the Estonian views on international law in cyberspace 6 years ago at this conference, she discussed collective countermeasures based on a principle that if the international community wants to keep the international order that is based on rules, that order requires effort by the international community to stand up for those rules. And she described collective countermeasures as one tool in the context of others in achieving that aim. So that is what I'm going to do in today's discussion as well. Discuss collective countermeasures next to other options when the international community or a state is faced with the question there is a threat to a legal norm, but also to the wider international community. What do we do? So to get ourselves on the same page, I've devised a scenario to help along with the discussion. So first of all, there is a state. State A, you can also call them the good guys, targeted by a hybrid attack. Now, law does not discriminate, again, between domains, but since this is cyber conference, let's say this hybrid attack comes in the form of a cyber campaign aimed at derailing that country's ongoing elections. Now, or let's put ourselves in the shoes of a state decision maker. If we like smaller shoes, we can think of ourselves as a governmental advisor to the state decision makers. In any case, we are faced with the reality that if a situation arises, a decision needs to be made. Something needs to be chosen between the options. let's call ourselves State C. Now, our intelligence agencies assess with high confidence that very likely this cyber campaign is conducted by State B. Let's, for this purpose, call them the bad guys, to redefine the future of State A and, in the longer term, the wider international order. What do we conclude already from that? One, a common understanding would be that State B has conducted unlawful intervention against State A. And if other conditions are met, State B is authorized to conduct individual countermeasures. And this is not controversial. Now, for the purposes of this exercise, let's also assume that State C has capabilities to impose costs on State B to stop their violation. And given that we're talking about costs high enough to actually change the calculus of a larger nation, we can assume that most would agree this counter-operation would breach the principle, at least the principle of sovereignty. Now, in this situation, what options do we have? And before that, just for the fairness of the general debate, this example, concentrating on unlawful intervention, is a step further or pushing the envelope compared to the current discussions that mostly concentrate on a narrow reading of erga omnes obligations set on the examples from the Barcelona traction case. But let's take this example, because if you're not taking the next step, pushing the envelope at a conference, bringing together legal minds from around the world, and the conference is named Next Step, then where are you going to do it? So let's keep with this example, and I'm happy to answer why intervention might be relevant in real life as well. So what are our alternatives? Firstly, the individual State B, could have the capability to conduct countermeasures themselves. And in this case, legally, this would be the best option. But as we know, this is not always the case, especially in a case of power imbalances. And this is why we are talking about collective measures to maintain accountability in the international rules-based order. Whether that's by states or the Security Council or by courts, we recognize that we cannot leave all situations simply to be dealt with by the one targeted. So now we're getting to the realm of cooperation. As a first option, we could think about assistance. We could think about helping the affected nation to conduct countermeasures themselves, but remaining on the back lines. Now, the concern, especially in cyberspace with this, is that cyber capabilities are very secretive by their nature, which means that we might not be able to, we won't be able to simply hand that capability over. We could try to hand part of the kill chain over, but if we're too careful on that front, we're risking doing not enough and mission failure. As an alternative, we could be more forward-leaning in our support and essentially start carrying most of the heavy load in that operation. But the risk here is, at some point, we're going to start finding that there's a blurring of lines in our responsibility. Because if we're doing all of the heavy lifting, if we are providing the target intelligence, the target access, the payload, and the operational management, then at some point we're going to start asking ourselves if we're really in assistance or have we become in charge of the operation we're assisting. So if that blurred line situation of our responsibility is beyond our risk tolerance, we have to look at the next option. Perhaps we could conduct the entire operation ourselves. The way we planned it, imposing costs and stopping the violation. But we would reject the notion that this crosses any legal line. This would be called a retorsion. It would not require a legal basis. It would not have a legal framework around it. The concern with this approach that has been pointed out previously is that by doing that, we would have to accept the legality of similar operations when conducted by anyone, including by our adversaries. Now, this is a possibility, but for a lot of states, not a realistic one, because their views taken in general, are more conservative on what states can and cannot do to each other, including in cyberspace. So if we are one of those states with a more conservative view, that option is off the table for us. Now, the next option could be that we find that there is no legal possibility to do anything close to imposing the costs we were talking about. We could try lesser measures. We could try diplomatic messaging, anything that is not crossing the legal line. Of course, the risk here is that we're not doing enough. The country whose calculus we are trying to change feels that this is not really, their goals remain the same and the malicious election campaign continues. Now, if that fails, the longer term risk is that the tensions are there and they're going to increase, and we might find ourselves with the least preferable option, the one that Gwendolyn talked about, where the only tool you can grasp for, and taking into account that the situation has intensified, is self-defense. So we would unlock the part of the toolbox that we really want to reserve for only the gravest of cases. And Gwendolyn made the excellent point there. I will not go further on that. Now, after having exhausted these alternatives, we might start finding that collective countermeasures could be a good option legally. But finding legal options is only part of the picture. There are plenty of reasons why, and as René Werk previously mentioned in one of the previous stages, there are plenty of situations where something could be legally a possible option, but it's simply not the right thing to do for a number of reasons. Firstly, something that has been discussed a lot is attribution, especially at the speed of relevance. So you might find that the picture is not really coming together enough to sustain a counter operation. You find confidence in the knowledge that this picture does not have to rely only on technical indicators. It can be based on an all sources of intelligence approach. You also can rely on the understanding that the legal bar takes into account what is reasonably possible in the context, but it is possible that the picture simply is not coming together quickly enough. You have reasonable basis to suggest that it very well could be independent hackers, a terrorist group, another country wishing to incite a conflict. You're simply not confident enough. In this case, countermeasures would not be the right option for you. The second possibility is that you assess that conducting countermeasures would be not beneficial or would be dangerous towards escalation, because adding more players to the game, and especially in the cyber context with unforeseen consequences, the situation is starting to look too dangerous. That very well may be the case, but at the same point I would point out that overreacting is not the only way towards escalation. Sometimes underreacting is. There are some situations where, and some states in some times, who are determined to change what rules apply and to whom. And remaining passive in relation to these states does not keep them in line. It emboldens them to take the next step and escalate further. Coming from Estonia, one example comes to mind very quickly. But Russia is by far not the only country that we know, at least today, respects laws only so far as they are coupled with force. In relations with these countries, being passive is the way towards escalation. And finally, it is very possible that with all of these steps checked, helping that nation is simply not in line with your policy and strategy. And again, this would be not the right choice. Now, as you can see, there are plenty of reasons why collective countermeasures might not be the best legal option or might not be the right decision. But that is not really the point. The point is that it is one tool in the toolbox of the international community to protect that very same rules-based order. Without that tool, and here you're going to get a different set of slides that show you the gap that Gwendolyn mentioned. Without that tool set, we're looking at a interesting situation where we starting from above, there is no controversy that in case someone uses armed force against the state, collectively the international community can intervene, whether by collective self-defense or through the United Nations Security Council. And in the below levels, although not legally regulated, it is fully accepted that if someone conducts an unfriendly act, for example, sends their spies to a country, to an international organization dealing with chemical weapons without anyone's consent, that there is a response, not only by the host nation, but by the international community, doing something legal but unfriendly, such as sending out people with diplomatic immunities. Now, in the middle is the question of what there. Without collective countermeasures, we don't really have a commonly understood and commonly agreed framework with the limitations that Gwendolyn previously spoke about. We have what is known the gap. And here we have two bad options. One is that the gap is going to remain unfilled, and therefore that is the area where if you want to test international rules-based order, that is where you're going to play, because no one is going to face you there. What is equally realistic, and perhaps more concerned to those who are concerned about escalation management, foreseeability, transparency, is that for those that are interested in that gap being closed, we've all been in situations where you're faced with a problem and walking back is really not the option. So what do we do in that situation? If we don't have a good tool, we use the next available tool. So what is very possible that if that middle gap remains practically unfeasible, it is going to be filled. It is going to be filled by closing the room from above and from below. More likely from below, given the high threshold of armed conflict. So we might start seeing steps that are taken where they're not stated as countermeasures, but they are in effect fulfilling that gap. But when that happens, that is going to not happen through a commonly agreed framework, but piecemeal, step by singular states taking action. So I would posit to you, does that look like a more transparent and more foreseeable development than accepting that collective countermeasures could be applied? I would posit that the better alternative would be to accept it, and concentrate not on the question of if, but the questions of when and how and that is exactly where Gwendolyn's paper hits, and I also highly suggest you read it. Thank you very much.
Thank you, Lauri, and I also have one additional question to you. I would argue that international law is conservative by its nature, and it develops reactively in response to the situation on the ground. So do you think that the states risk by not expressing their views on collective countermeasures, when they continue to avoid clarifying their position? And I'm speaking also, well, not speaking for the Czech Republic, but I would just say that the Czech Republic has considered this topic, but decided not to include it in its national position. So do we risk something at the moment, or is there still time?
It's a good question because there are pros and cons. So the discussion on the developing a national position and the book presented there, I understand, includes reasons why you might want to publicize your positions. For empathy towards those that are more careful, you need to consider firstly that you are, when you're in the position to provide your nation's view on international law or any other, in any quickly developing situation, you can picture yourself standing on a beach and you're asked to pinpoint the flag to a position that you think that the waves are going to, the furthest wave is going to reach. And you don't know, and you know that times is, even if it reached here last time, it might change. So times are changing, and cyber, especially with cyber operations and their secretive nature, there are reasons not to, essentially, to be careful. At the same time, this publicizing the views helps you think through this in an interagency approach, and gets you, in the case of a larger position or a framework position, gets you in a better situation in case something actually happens. So you don't have to essentially make up a framework of action in hours. You can base your singular decisions on a predetermined framework.
Mm-hmm. Thank you. So with this, we can continue with the next presentation, and Stephen will provide an overarching view, drawing from his vast experience with international law and international organizations.
Thank you so much. It's great to be here. Thank you very much for your interest in this subject. So my remarks today, I think we've had, first of all, I think want to compliment Gwendolyn, Laura for excellent laydowns and overviews of the subject. So I thought what I would do is focus on the evolving role of international organizations, just based on my own personal experience, NATO, European Union, and the United Nations in addressing issues related to collective countermeasures in cyberspace. Now, you might already object to this presentation because it's maybe impermissible to lump such different organizations together into one presentation. They're obviously very different, but in the spirit of CyCon, I'm going to try. Before I turn to the substance of the remarks, I'd like to just briefly situate my own perspective. I did have a chance as the legal advisor to former Secretary General Stoltenberg to participate in a number of North Atlantic Council discussions of how international law applied to cyberspace. I had a chance to see how NATO states used processes like the Tallinn Manual, as well as the CCD-COE more broadly to flesh out and discuss things. Collective countermeasures was obviously one of the most contentious issues that came up in those various venues. After I left the NATO headquarters in 2020, I had actually intended to write a paper about the issue of collective countermeasures, but, and in fact, Laura, who worked in my office at that time, did a ton of research for this. I ultimately decided it wasn't really appropriate because there was such a divergence of views amongst states on the subject. And so I'm kind of coming back to this issue after 5 years. Things have had a chance to settle down a little bit. As we just heard, there's obviously not a total consensus, but, you know, I think things are shaking down. One of the lessons I've learned from this experience has shaped my view that in situations like this, international organizations are even more indispensable, even if they're still evolving, actors in the enforcement and operationalization of international law in the cyber domain. And so the role of international organizations, which I'm going to describe as part of this presentation, I think really points to a way to accomplish what Gwendolyn and also Laura were kind of advocating, which is the need for more discussion in the international community that will build more comfort around this concept. So I'm just going to go through some key developments in the world of international organizations from 2020 to 2025, then talk a little bit about, specifically about international organizations and collective countermeasures, and what are some of the unresolved legal questions and challenges. You can kind of include everything that was already discussed, but there are then specific issues that I wanted to highlight for your consideration. And then thirdly, I wanted to try to give a sense of what actually happens and what to do about it. So key developments from 2020 to 2025, there has been, in the field of collective attribution and solidarity, state and international organization cooperation in that area, in other words, publicly attributing cyber attacks, has increased. A prominent example was the coordinated attribution in 2021 about the Microsoft Exchange server compromise and attribution to state-backed hackers. As you probably know, NATO issued a statement of solidarity with those affected and explicitly acknowledged, and I'm quoting because the language is significant, acknowledged national statements attributing responsibility to the People's Republic of China. Likewise, the European Union and several other states jointly condemned that operation. That kind of collective attribution effort, I think, was seen to enhance the credibility of the findings and to set the stage for unified responses across a variety of realms, like diplomatic démarches, sanctions, etc. Another example of recent state practice, cyber sanctions regimes. So the European Union's cyber diplomacy toolbox, which was often discussed at CyCon, started to be really activated from 2020 onward to sanction individuals from a variety of states for major cyber attacks. These measures, which are, sanctions, travel bans, asset freezes, bars on funding, et cetera, represent collective countermeasures that are really short of forcible countermeasures, of course, and they're taken by the 27 states together. So they also complement similar actions by other coalitions. So they might not be the exact kind of collective countermeasure we're discussing here, but I think it shows a movement to working on that in the multilateral space. Operational cooperation and assistance. NATO and the EU have both emphasized practical support to members who are facing cyber incidents. NATO's 2021 policy, as well as its subsequent work, and in fact its ongoing work, commit allies to mutual assistance. The EU, for its part, has the cyber rapid response teams, which were, of course, deployed following the Russia's further invasion of Ukraine in 2022. That's not really a countermeasure, maybe, that we're talking about, but it's another example. And then finally, information sharing and attribution support. IOs have become hubs for sharing the kind of technical information through such things as malware information sharing platforms, the INTSEN or CCERT networks. We've learned from cases, for example, of the 2020 SolarWinds intrusion, that timely sharing of attribution evidence is very important. What I think is interesting, if you look at the way in which IOs rolled out these measures, they've always tried to remain what I think has been called norm sensitive. Both the EU and NATO routinely reaffirm that their actions in cyberspace will respect international law and the agreed norms of responsible state behavior. I think everyone knows it here, but it's important to communicate it properly. I think that shows that states are really keen, and IOs are keen, to show that we're not talking about a kind of vigilante justice in the field of collective countermeasures, because that indeed is one of the main criticisms and critiques of collective countermeasures, is this perception that they could lead to uncontrolled escalation and possibly abuse. So states, I think, have been very careful in the past 5 years to do things that look a little bit like the realm of collective countermeasures in a way that really emphasizes their legality and the kind of controls on them. So that's kind of the state and IO practice in a way. What are some of the unresolved legal challenges and questions? We've already discussed the overall issue, but there are a number of IO-specific issues. A central unresolved issue is whether IOs themselves, so the international organization itself, can invoke or authorize countermeasures in cyberspace, and if so, under what conditions. So could an IO like the United Nations or a regional alliance authorize its members to carry out cyber countermeasures? Of course, formally speaking, and it's pretty clear, an IO cannot make an unlawful act lawful vis-a-vis others just by acting within its own framework. Certainly the UN Security Council, which we've already heard referenced, acting under Chapter 7, can mandate sanctions and other measures, although there's a question about whether that's practically possible given the world situation. But it's clear that organizations like NATO or the UN cannot legitimize or legalize, so to speak, a cyber counter measure that would otherwise violate international obligations. Also, we haven't entered into it, but the draft articles on the responsibility of international organizations really do caution that IOs themselves can kind of incur responsibility if they're seen to be authorizing member states to commit acts that would be wrongful for the IO itself. That's kind of an exception on the back door. Another gray legal area is whether the IO can really truly be considered an injured party in the cyber context. This is a question that has to do more with the practicalities of the way that IOs work. If an international organization's own networks or operations are hit by a malicious cyber operator, for instance, a hack on a UN system or a NATO system, could the organization itself invoke countermeasures in its own right? Dario, or just general principles of law of responsibility, would suggest that yes, in theory, an IO in such case could take countermeasures. against the responsible state, provided, of course, it meets the relevant conditions. Yet we have seen scant practice and precedent for this kind of activity, thank goodness. And this is probably more a function of the way in which IOs actually work than any kind of legal problem as such. Now, so those are two legal kind of questions that I have with regard to IOs in the area of collective countermeasures. Maybe the third thing I want to put on the table is what actually happens. And one of the reasons that we don't see too much precedent practice, I mean, one reason is, of course, the secrecy and that type of issue. But in the context of IOs, in reality, the IO is much more likely to rely on its own member states to carry out any sort of collective countermeasures or related things. And let me explain that. Indeed, IOs often end up supporting member state countermeasures rather than acting unilaterally. NATO, for instance, is well known, has no autonomous or independent sanctions mechanism. Of course, it can coordinate political pressure or defensive measures of lots of sorts by allies. The EU, by contrast, with its own legal personality, can impose measures like asset freezes, travel bans through joint decisions, which effectively enable member states to respond collectively under an EU umbrella. Although it's not really a thing in practice, there's no reason that states can't use venues like NATO as a way to similarly not take the decision, but to coordinate their own views. So one challenge that you have in trying to understand the role of IOs or potential role of IOs in collective countermeasures, apart from the serious differences between IOs, is that IO coordinated responses, by their very nature, tend to blur the line between unilateral and collective action. So you really have to, analyze it carefully. You should ask yourself the question, when states act collectively via an international organization framework, are we witnessing a true exercise of collective countermeasures? Or are we just looking at a series of concurrent national measures? That's an area where I think lawyers probably have a difference, and of course you have to look at the nature of the IO itself. There's an issue also with IOs, it's not really a legal issue, it's beyond a legal issue, it's more of an operational issue. The operational capability of IOs, as I was saying before, to exercise countermeasures is also in and of itself a limiting factor. Even NATO is not hacking back, so to speak, in the sense of a countermeasure. It would be member nations that would do so even if they were acting under a kind of collective decision. International organizations typically lack, even ones as strong as NATO typically lack their own independent cyber capabilities, and they depend heavily on the technical infrastructure, intelligence resources, and operational expertise provided by member states. Furthermore, IO mandates often restrict direct engagement in coercive or punitive measures. I would say that the general vibe of IOs is to favor diplomatic, normative, and cooperative functions instead. So, for example, just to talk about NATO, while it facilitates collective cyber defense, the CCD-COE is all about cooperative cyber defense, its actions ultimately rely on the capabilities and decisions of its member states, which retain sovereign control over any operational countermeasures. Finally, and this is a mixed legal, operational, and political issue, I would say, IOs face significant procedural constraints. In the case of NATO, they require consensus. In other situations, they have their own decisional rules, but they generally require broad agreement amongst a wide range of member states before taking collective action. That makes swift and decisive IO action highly challenging, and this composition can complicate, of course, unified decision-making. So I feel like I've kind of raised a number of questions about the possible application of collective countermeasures in an international organization setting. What would we do about that? And I have a couple of proposals before I conclude my presentation here. Recognizing these constraints, I think that a viable way forward would really be in this period where we're kind of, I would say, getting more comfortable with the notion of collective countermeasures, to focus on strengthening the capacity of international organizations to effectively coordinate and legitimize collective state actions without necessitating independent operational capabilities. IOs can really enhance their roles supported by their member states as hubs for example, cyber intelligence sharing, joint threat assessments, and unified diplomatic engagement. I would say that establishing clearer procedural guidelines within whatever the IO framework might be that would promote rapid consultation and coordinated responses really could facilitate timely collective action without running afoul necessarily of the existing mandate. What do I exactly mean by clearer procedural guidelines? This could involve establishing predefined protocols for rapid consultation among member states in the event of significant cyber incidents. You could actually think about NATO's work and the EU's work in this space as totally designed to do that, but there's a lot of further work that could be done. There could be criteria for collective attribution. Gwendolyn, maybe your paper would be a good place to have a look. Mechanisms for swiftly reaching consensus on responses. And I think those procedural improvements would have a lot of advantages. I think in the end that to answer the question posed at the panel, do collective countermeasures in cyber strengthen international law's response to unlawful cyber operations? I think the answer is yes, and I think that international organizations are well positioned to help narrow the gaps that we see at present by not only facilitating state dialogue, but helping build shared interpretive frameworks and promoting common thresholds of response. I do think there is a role for them, and so I really do appreciate being included here to talk about that perspective. Thank you very much.
So thank you very much for this very comprehensive and fascinating speech. Actually, one thing that I came to realize that the EU cyber diplomacy toolbox, when it's applied, the restrictive measures from there, that it actually has some serious international law implications. So that's a very important remark, I think. And I would like to perhaps add one more question on top, and I would like to ask what would be your advice to a state that is considering joining a coalition or maybe joining a coalition of states that are about to engage in countermeasures, or when the state itself wants to form such a coalition. What would you advise?
Yeah, and thanks a lot for the question. I like the use of the word coalition because it kind of adds this other gloss to the world of collective action. You know, I was talking purely about international organizations. Then you have kind of groupings of states, but I think the legal advice is, always going to be the same. You obviously need to have a clear legal basis. We've already talked about some elements of that, but that would be, for just to come up with a few issues here, evidence of attribution, for example. And importantly, especially given the secrecy of these issues and the difficulties of multilateral communication, information that can be shared and communicated. Very hard, or can be hard. But anyway, I think it would be advantageous because it helps improve credibility. I guess the second thing I would say is, this issue of the injured states, you were framing it in terms of consent. Gwenda, you could also kind of back it up almost. The injured states request, is very, very important as well. It's interesting, we can talk about it in a bit. The unwilling and unable test, as far as I remember it from after 9/11, was designed for situations where the state didn't really consent. And so it's interesting that we're going back to what was, I think, perceived as an issue there. Obviously observe the legal conditions that we've been talking about. Laura gave a great brief about that. Coordinate diplomatically and publicly. So public diplomacy, as I was saying, is quite important. And then finally, really weigh the political and security risks of such a measure. I think at the end of your presentation, Laura, you kind of had that slide of things that could spiral. And I think they can be managed, but I think it's very important to consider. Mm-hmm. Thanks.
Thank you. So I think we can start taking questions from the audience. I'm sure there will be some. Yes, please.
You gave an awesome presentation. Yeah, thank you. So my question is primarily to Larry, but also to the entire panel. So I find your arguments in favor of collective countermeasures persuasive from a policy perspective, but my question is primarily juridical in nature. So first, is your proposition a matter of lex lata, or is this a proposal de lege ferenda? And second, what is your assessment regarding the extent to which there is widespread and representative practice and opinio juris in support of this conduct? And how many states have actually invoked this right and respected the safeguards in Article 52 of our CIWA? And finally, is this a proposition under general international law or a lex specialis just for cyber, as envisioned by Article 55 of our CIWA? Thank you.
Thank you. So I think there are 3 questions already. So
Thank you. Yeah, I got 3 or 4, but I'm going to try to go over them as quickly as possible. So in the case of national positions, sometimes it's quite difficult to differentiate between what law is and what it should be. So you very rarely see national position of saying we would want the law to be something. You state the law to be something, and for you that is the case. And whether that the international community joins is a matter to be foreseen. So if you're asking if it's a fact or an aspiration, I would call it an aspirational fact. But again, take it as my personal. With the opinion juris and state practice, it's difficult to answer both of those. So you would find better sources from the academia looking at different international actions going back past years or decades. It's so difficult for me to classify something for a nation when that nation has not done so themselves. For opinion juris, this is one of the cases where it's admittedly, I have no example where a state has raised their hand and said, we did collective countermeasures. And that might remain the same for a while, because you would have to take the hit of admitting, we conducted a cyber operation. And if you ask operators, they'll tell you the best cyber operation is something that no one has ever heard about. And even the policy folks are going to tell you it's rarely a good reason to message that you've conducted an operation. So you will find smaller examples of those. And leading to your final question, the position was on general law, not cyber specific, and that is at least my view. So, and that is one of the reasons, the difficulties in cyber is one of the reasons why we might see and are seeing the discussion of collective countermeasures move to other areas, such as sanctions, could move towards law of the sea issues, where the complexities of secrecy and speed are less on the table, and the question is perhaps more sort of, you get a better feeling of the facts. But that's all for me. I don't know if others would.
I just want to add something on the final point. I agree with you. I think the debate around it has always had a view toward the general law and not lex specialis, and I think that's correct. There's a new article in the Stanford Law Review by Ona Hathaway of Yale Law School and some of her students about war reparations and using collective countermeasures in that context. And I was just looking at it to prepare for this panel, and she said, wait a minute, this issue might also have impacts in the cyber world. So I think people are starting to realize that this issue is more of a general nature, and that's probably right.
Mm-hmm. Yes. So this is also something that you probably mentioned in the morning panel, that the cyber implications might have the cyber might have implications into the more general questions. Yeah. Are there any more questions? Yes, Agnes, please.
Thank you very much for this wonderful panel and this good discussion head of Law Branch CCDC, Agnes Kasper. So my question would be kind of NATO specific. So might take it, Stephen or Laurie. Mm-hmm. So looking at international organizations acting in their responsibility and potentially engaging in collective countermeasures. In NATO, there is also, when it comes to the specific cyber field, there is this mechanism called SCEPA. Yeah, would there be any kind of controversy, or would this framework be, excluding the possibility of taking collective countermeasures by international organization? Do you see? What's the interaction between these two areas? Thank you.
Do you want to take that one?
If you have a line on that, then I'm happy to give it to you.
No, go ahead. I'm only throwing him under the bus. No,
yes.
It's something.
I would perhaps say, if you're asking, is there conflict between these two areas, then I would say no. And you have, as Stevens discussed, the international organization definitely has a role to support, and perhaps the international organization can do things that the states themselves, without that framework, could not to achieve their effects. The general response on who's responsible would be the states are quite willing to say that if there is an operation with outside world effects, then generally the states are responsible for that action, and the international organization then could be, but the states do not park their responsibility in the organization when they go acting. That's my
I agree. I think that I don't see any necessary conflict between the kind of policy framework that NATO has and the ability. First of all, just in principle, the ability of NATO states to agree to anything that they want, as long as it's in line with international law, right? As long as the North Atlantic Council decides it and it's within the mandate and it's somehow not violating a provision. So. I don't see a necessary conflict, but I think it points to the fact that there are divergences of views, and the framework is to put my kind of view on it. It's a way to help manage those differences, not necessarily a way to sort of shut down action. But thanks for that question. I'm sorry if I threw you on.
Thank you. Always appreciate the challenge. Thank you.
The gentleman, yes.
Paul Wrange, Stockholm University. Like my neighbor Mohammed, I have some policy sympathy for the idea of collective countermeasures, but I also have some legally speaking, I'm not convinced yet. But anyway, so assuming that it's a good and legally viable idea. So thank you, by the way, for 3 very clear presentations. So focusing on Lauri's scenario with state A, the injured state, B, the alleged guilty party, and C, the assisting state. Now, of course, countermeasures assume that there has been a breach of international law. And when we speak of cyber operations below the use of force threshold, states have widely different views of where the bar is for what is unlawful. And that spread is within NATO as well. So now, assuming that state A, which puts the bar quite high, claims that we have been subjected to violation of international law. A foreign state B has, they have committed a data breach, they have destroyed data, they have, and there's loss of functionality and so forth. And then they call on their friends and say, well, we need some support here. And country C responds, well, we don't think that act was actually a violation of international law. So, but we will nevertheless help you. So, but we will do that sort of out of political sympathy. And we will conduct a number of measures which you think per se violate international law, but which we think are just acts of retortion. So I wonder, would that kind of situation create legal or political difficulties for any of the parties involved? Thanks. It's quite hypothetical.
To start with, I think you're pointing to actually one of the benefits that you can have for collective action, because going to fight someone alone is a much easier decision than convincing your friends to go and fight them, because you have to answer the questions of is it really the right thing to do? Now, for those states, if they conclude that it's an unlawful situation, that the response would be unlawful, I think it's quite unlikely that they are going to start sort of cutting facts in half and saying, we think what you're doing is unlawful, but we're going to help you in any case to the exact limits where we would be responsible. So that's a very risky situation to be in. So what is, I consider equally likely is the other states saying, hold your horses. We might be able to do something collectively, whether a countermeasure or not, but essentially the end response being a more moderate one, given that it was included colder heads in the decision-making process. Mm. That's my shot.
I see Heli raising her arm.
Yeah, Heli Dirma-Klaar, an Estonian who was involved both in the EU cyber diplomacy toolbox development and in developing the position of the Estonian collective countermeasures. My question is a policymaker's question, since I'm not a lawyer. Before we get to the countermeasures, the governments have to agree on collective attribution. And from my experience, this was the most difficult part when we did the EU cyber diplomacy toolbox. How we are exchanging information, what kind of maturity is there amongst the nations to share that information. We could not apply the first set of the EU sanctions because we could not get together due to COVID in Brussels, and European Union member states do not have secret system to exchange information at the classified level amongst each other. So we had to wait for almost a year before the physical meeting started so we could get together physically in Brussels and share information. So I don't know, you as the lawyers, of course, you cannot solve the policy question, but my question for you is that what is the level of proof you need as lawyers before deciding on any question on countermeasures? Or is that a policy question or legal question?
I would perhaps add on another layer to this question and ask whether the evidentiary standards are somehow comparable among the states and whether that affects the decision making. Who wants to take this?
Do you want to start?
Why don't you take us first and then I'll add on.
My impression is that it's a mixed legal and policy question with a heavy weighting towards the policy side of the question. And it turns on exactly like almost mundane seeming technical issues sometimes, as you say, Heli. So just in my experience, I'm trying to rack my brain. I'm not sure that states would say that they have different evidentiary standards as such. I think states would probably articulate it in kind of the same way, but the kind of risk tolerance, if you will, and like the degree of which in which states are kind of like show me the documents, or what is it now called, show me the receipts, is varying. And that's maybe a kind of bureaucratic or political culture issue. It might turn on technical capabilities, and it might have to do with like the overall information and intelligence context in countries. So I would say, like, I always used to say to people, it's not a legal issue, but it's mostly a policy issue. That's how I would answer.
Can I add on?
Sure.
Yeah, and I would also say, regardless of whether we address this issue in collective countermeasures, it's going to continue to pose a problem throughout cyber operations, right? This is when we're dealing with classifications, we're dealing with different countries and different standards. This issue is going to repeat itself frequently, and so I think that what you're raising is that we do need to, in all realms, build pathways to share this information, because, one of the speakers yesterday literally said cybersecurity is going to become just security, right? Cyber is going to underpin everything. And I do, in fact, kind of to echo your point, see that this is eventually going to probably invade almost every aspect of the law, right? We're going to have all of these evidentiary standards. We're probably going to have cyber forensics backing everything up. and how do we communicate with each other? I think it's this kind of underpinning theme of collaboration and coalition. We're going to have to solve this problem regardless of what arena we're solving it in.
Any more hands? The gentleman at the back.
Thank you. I have two aspects or two questions. One is when it comes to international organizations, they are hosted somewhere. And most of them, you talked mainly about the EU and NATO, which are very strong international organizations. You have others who are not in the realm of security. So one question is, what's the role of the host nation? Mm-hmm. And the other question is, many personnel of international organizations, they have within the host nation, they have immunity. So could they take countermeasures by themselves or on behalf of the international organization and be exempt from prosecution?
Wow, that's a great question. I was thinking about this, addressing this issue of the host nation in my presentation, but I decided to keep it to the member states in general. The host nation definitely plays a special role in protecting the cybersecurity of a place that's IO that's located in its territory. And you're talking, I mean, that becomes more relevant for every organization, but you're talking about the fact that different IOs have different capabilities and capacity to do stuff. Some are super small, right? And they might completely depend on the host nation, right? Or they might have member states that don't have very high capabilities. So the host nation has a special role. In practice, I don't think it's the sole kind of protector of the IO, if you will, because in practice, I think it's something for the member states in total. This issue of immunity, they may have some kind of immunity, they might not have immunity. It depends on the legal framework for the international organization. I mean, I don't think that IO personnel could be encouraged in any way, shape, or form, from engaging in activity that would otherwise be illegal and then sort of relying on their immunity. I think that runs against kind of definitely the best practices and the way in which any kind of IO general counsel would approach the matter, not only the general counsel, the chief executives of IOs. But you do raise a question, and I was trying to allude to it in my presentation, can the IO be a backdoor, so to speak, to, not via immunity, but just via regular decision-making process? Can it be a backdoor to something that the states can't do themselves? It might be appealing somehow, but I don't think it's a really good idea because ultimately it would, I think, really undermine the IO itself. But thank you for the question. That's a great one.
Maybe I can take one question or have one question. I would like to ask primarily Gwendolyn, but maybe the others can also chime in. In practical cyber operations, where would you draw the line between lawful assistance and participation in countermeasure that could trigger state responsibility? How far can an assisting state go, and whether you have any experience with this?
I will not speak to my experience with this, but what I will speak to, any line drawing exercise, I think at this point, especially when we have kind of a limited number of case studies that we're actually drawing from, is probably going to leave something to be desired. But I do think, in our discussion, kind of as you hit upon, talking about the consent of the state, talking about, is this a request, right? I think those are going to be the elements that are going to be really crucial in keeping this in a realm of responsible state action, because I think that when we're talking about actions that might go too far, we would be aided by having a standard that would tell us when that state has gone too far. And so I do kind of wonder, the Talon Manual contemplates the countermeasures taken directly against the non-state actor. I think it kind of is incumbent upon the international community to decide what our comfort level is as these case studies do come up. yet again, kind of harkening back to our discussion of how do we share this information, I think we're going to have to find a comfort level in sharing our case studies with each other, whether we create the forums to do that or not. I think that's how we find that line, because we're going to at some point have to guess what the standard is and then put it into practice. We are governed by a law that is shaped by state practice, and I think that's really important to recognize in the realm of cyberspace.
Mm-hmm. Thank you. Up there.
Thank you. My name is Anne. I am currently a visiting scholar at the CCDU Law Branch as well. My question is maybe partly a political one, but there was a time where there was a lot of talk about the responsibility to protect. And we've heard also before the kind of digital divide also in cyber and in AI, which is going to be enhanced by AI, is just going to grow. And so if we consider that, yes, some states will definitely not be able to respond or will just be way more victim to some cyber threat than others, do you think there's any chance that this responsibility to protect, if we think it's good or not, might find its way again in that also collective countermeasures would be a part of that into in assisting? It's yeah.
So, first of all, I'll align my answer to your question, but given the situation, you could actually fit that in more easily than the intervention example I brought it, because currently the discussions are centered around the erga omnes examples as brought by the ICJ in the Barcelona traction case, which, for example, includes the prevention of genocide, self-determination of peoples, aggression, probably less linked. So if there was a link to those, then it would be more, based on today's discussions, it would be more easily discussed that collective countermeasures would fit. My question and why I brought the intervention example is the Barcelona traction case is 55 years old, and the court explicitly stated these as examples, not as a closed list. But the useful thing about examples is that they're good to hold on to. The bad thing about examples is that people keep holding on to them.
Yeah.
I would posit the question, and if anybody's interested in academic work, and look at the list and ask yourself, in the year 2025, is that really the entire list that states owe to the international community as a whole? Or perhaps, given the closer interconnectedness of states, that list should be expanded, and could include through the way of these examples the responsibility of protect discussion as well.
I mean, R2P, yeah, it's true, we don't talk about it that much these days. Like, if you think about it, though, in the intellectual history of international law or international politics, I mean, first of all, it's a fairly limited doctrine to certain areas, as you're saying, Lauri. So I think it came from a little bit of the same place as what some of this collective countermeasures and erga omnes is coming from. Like, so it's interesting, you had a section in your paper, Gwendolyn, about like the intellectual history, if so to speak, of this idea. I think that could be an interesting kind of angle to bring into when you're thinking about it, and it's because I do think it's somehow related to this idea, even if it's not very much on the radar screen these days. So thank you for bringing that up.
Thank you. Well, maybe I can push you a bit on this question and ask whether the violations of erga omnes obligations can justify collective countermeasures, because this seems to be I wouldn't say the majority position of the international positions, but there is definitely a certain recurrence. So do you think this could be like this middle ground or a certain step towards collective countermeasures?
I think it's a useful development in the discussion compared to including 2019 when Estonia's position was favored, because I have not at least seen an example or case made where there's simply a bilateral issue. Someone violates a contract, then some third state, out of a plethora of motivations, including just wanting to damage the one that happened to violate the contract, steps in and interferes. So it's easy to see a number of ways how that could go very wrong very quickly. So moving towards the idea that was expressed or reflected in President Karilai's speech as well, is that the purpose of this is to safeguard something that is considered important for the international community in a wider sense. And then we will turn to the question whether the short list of examples in the Barcelona attractions is sufficient, or we should move towards the middle ground from that as well.
Mm-hmm. Yeah, I would also add there is definitely momentum in this direction. I would say the paper that Stephen earlier brought up, the Una Hathaway paper, has a pretty lengthy discussion about erga omnes violations in reference to countermeasures, and it runs through Article 48.1, and then it goes to the Gambia v. Myanmar, and kind of has a very nuanced discussion of that. Like, you can see that there is this kind of push to find out how we can use, I think, the erga omnes violation in this space, and I think there's definitely, I would say, a developing consensus among the state position papers that this is kind of where we need to root this doctrine.
Mm-hmm. Thank you.
Maybe I would just say, actually I don't really believe this personally, but I wonder if there's a disadvantage to this. It's got a tactical advantage because it kind of, erga omnes obligations definitely generate a lot of outrage and things like that. But they also kind of raise the bar of seriousness of the issue, that it makes it maybe possibly impossible for people to get to the level to say, oh my God, I'm going to sign off on a collective countermeasure. So I wonder, I don't know, technically I wonder if it might make sense, because there's nothing theoretically that's, could be any violation of international law. You were saying that we can't come up with an example, but I bet you there are some examples of a state that kind of asked for help on something, and it was, there are probably things out there that are lower on the radar screen that even have happened. And I don't know if that's a way, if you're advocating to approach the problem.
Yeah, I think that paper actually discusses kind of two different cases, right? One where you have the erga omnes violation and one where you don't. Mm-hmm. And it certainly, I would say, describes the second scenario as a little bit more of a controversial application. Yeah. But I would kind of echo that and say we probably don't want to make the erga omnes violation maybe the only way to get there. But it's definitely something that I've seen people talking about.
Yes.
Sure. If it's not taking for, I was just thinking, maybe you mentioned it partly already, if there are differences, regional or country differences in how much people accept or think about the idea of collective countermeasures, because as much as there are differences, regional differences on what is a breach of sovereignty or not in the cyberspace especially, do any of you have thought about that or looked into the differences on that?
Do you have any?
So I looked quite extensively at the state position papers in my work, and you can see that there are basically two main holdouts on collective countermeasures. You have France and you have Canada, right? And those are two technologically advanced countries that have really kind of raised concerns. And then on the other side of things, you have countries starting to coalesce behind the idea of collective countermeasures, especially states that have suffered from a cyber attack, right? Costa Rica, Estonia, states that themselves have been victimized by this kind of technological asymmetry. So I would certainly point you to the position papers of all of the different nation states. I mean, people are really being thoughtful, I would say, in their approach. There is kind of some variation across how far they're willing to go, right? Some states will say, full stop, they think that collective countermeasures are authorized. Some other states will say, in response to a breach of a customary international law, breach of a primary obligation, things like that, then those will justify countermeasures. Some states say, we're not sure, right? You'll find position papers that are across the entire spectrum, but at least in my opinion, there seems to be a little bit of a critical mass starting to settle on the side of collective countermeasures are justified in some circumstances, and then within that camp, there's kind of people that fall all over the place.
Do you see any difference in the... Sorry. Do you see any is it really just national positions, or can you see or recognize a pattern in terms of, as you were saying, for example, okay, these nations have been victim of cyber attacks, so they're definitely gonna say we need them, or do you also see patterns that are maybe really regional in that sense, out of curiosity?
Perhaps I'll use the chance to a bit widen the sort of the question of supporting it as a victim. So might not be the only explanation, because we're talking about the legal right to operate, and the legal right to operate is, when you assign for lawyers' case, it's for the helping nation's problems to solve. So the state that gets help, their lawyers aren't really thinking about what the legal basis is to help them. They're just happy to get the help. Given that you're talking about a list of countries that have been targeted by cyber operations, there's also a degree of, once you get hit by a bat, you start recognizing the value of a bat as a tool. So it's also a matter of thinking about what the legal framework is as sort of a operating nation.
And I don't see a regional trend. I don't think you can say that, like, X region thinks this way and X region thinks that way. Actually, there's a lot of diversity within the regions.
We have a few more minutes, but I have one question that I really wanted to ask. Since many of the opponents of collective countermeasures, they point to Nicaragua and they say, yeah, but the classical interpretation is that you can't really do this. But what could a modern interpretation look like in a cyber context, especially involving indirect harm? This kind of concept.
Perhaps I'll just start with Nicaragua on whether that can be classified as a limit. So two things that would differentiate the Nicaragua case from commonly understood countermeasures. Firstly, the paragraphs 248, 249 in the merits decision that decide this, they're concerned about use of collective measures using force. So that was most of the text in the paragraphs. And the case also included a situation where no request by the state was provided. So I would posit these paragraphs aren't really a prohibition. And on RCWA, Article 54, if you look at Crawford's commentary to that article, the express purpose of that language is to reserve the question, is to avoid a strict interpretation that countermeasures are only for injured states. So in my mind, both of these situations very much left the situation open, and then we get to the point that international law develops based on how the threat picture develops. Slowly or quickly, but we need to be moving for the law to adapt to reality, and that's sort of the basis of at least where I'm coming from.
I mean, I would definitely agree with you. I think it's very prudential to say that we can differentiate from Nicaragua just in the cyber context alone by saying this is so different than the kinetic realm that was being contemplated there that we have to think outside of what could have been foreseen at that point. I do think that our discussion about not limiting collective countermeasures in their development to the realm of cyberspace means you probably want to bolster that with some additional conversation, whether it's the consent, whether it's because we're below the use of force threshold. But certainly in the context of cyberspace, I find it to be a pretty compelling argument that we are substantially different from anything that could have been contemplated in 1986.
Yep, this sounds very optimistic. I hope that the ICJ, or we might get some more case law from various sources that might help shed some light on this. We are almost at past. Are there any more questions for the panel? If not, then please join me in applauding our wonderful panel today.